The Supreme Court chamber fell silent as Congresswoman Jasmine Crockett stood at the podium, her navy blue suit crisp against the mahogany backdrop, her shoulders squared with determination. Justice Clarence Thomas had just cut her off for the 6th time in 15 minutes, his deep voice booming across the chamber. "Congresswoman, that's not how the Constitution works." A tense murmur rippled through the gallery. Thomas leaned back, a slight smirk visible as he adjusted his glasses, clearly expecting Crockett to back down like others before her. But something shifted in her expression. Her eyes narrowed, her grip tightened on the podium. "Mr. Justice," she began, her voice suddenly steel-edged, "I've let you interrupt me 6 times. The 7th will not happen." The gallery froze. In the next 30 seconds, Crockett would deliver a response that would send shockwaves through the entire judicial system and leave Thomas speechless for the first time in his 30-year career on the bench. Before we dive deeper into this explosive confrontation, take a moment to like this video and subscribe to our channel so you won't miss our latest political analysis and breakdowns of the most important confrontations in Washington. The hearing had begun like many others, a packed chamber, the 9 Supreme Court justices seated in their imposing black robes, the weight of constitutional interpretation hanging in the air. But today's oral arguments on voting rights had quickly become anything but ordinary. Jasmine Crockett, the 42-year-old former civil rights attorney turned Democratic Congresswoman from Texas, stood as the unlikely challenger to the established order. With just 2 years in Congress, many had questioned whether she had the experience to lead this critical argument. But beneath her relative Washington newcomer status lay 15 years of courtroom battles defending voting rights across the South. She'd won cases others deemed impossible and had earned a reputation for unflinching precision under pressure. Seated at the center of the bench, Justice Clarence Thomas represented the entrenched conservative judicial power. At 77, Thomas had served on the nation's highest court for over 3 decades. Known for rarely speaking during oral arguments for most of his career, in recent years he had become increasingly vocal and confrontational, especially on issues of race and voting rights. His questioning style had grown more pointed, often cutting off attorneys mid-sentence. The stakes couldn't have been higher. At issue was the Voting Rights Protection Act, legislation that would restore federal oversight of state election laws, oversight that Thomas himself had helped dismantle in the court's landmark Shelby County decision a decade earlier. The case had the potential to reshape access to the ballot for millions of Americans, particularly in communities of color. As Crockett began her argument, tension filled the normally staid chamber. "The evidence shows systematic disenfranchisement in 12 states since Shelby County," she stated, her voice clear and measured. "Over 6 million eligible voters have faced—" "Congresswoman," Thomas interrupted, his deep voice cutting through hers, "these numbers are merely statistical manipulations. The Constitution doesn't guarantee convenience in voting." This first interruption drew subtle reactions from the other justices. Elena Kagan raised an eyebrow. Samuel Alito nodded slightly in agreement with Thomas. Behind Crockett, rows of civil rights leaders and community organizers who had fought for this legislation watched intently, their faces reflecting the weight of the moment. The battle lines were drawn. This wasn't just a legal argument, it was a confrontation between 2 fundamentally different visions of America, with the rights of millions hanging in the balance. Crockett recovered quickly from Thomas's first interruption, pivoting to specific evidence from her home state. In Dallas County alone, after Shelby, polling locations in minority neighborhoods were reduced by 74%. While that's a local decision, Congresswoman Thomas cut in again. The federal government isn't responsible for county-level resource allocation. The second interruption came with a dismissive wave of his hand. Several conservative justices nodded in agreement. Justice Barrett looked down at her notes, her expression unreadable. Crockett took a deep breath, visibly recalibrating. "Justice Thomas, with respect, these aren't isolated incidents. We've documented systematic patterns across multiple—" "Patterns don't establish constitutional violations," Thomas interrupted for a 3rd time, his tone growing more condescending. "You're conflating correlation with causation, a basic logical fallacy." A few chuckles emerged from the right side of the gallery. Justice Sotomayor frowned slightly, exchanging a quick glance with Justice Jackson, who had straightened in her chair, watching the exchange with increasing concern. The tension escalated with each interruption. When Crockett attempted to reference specific testimony from affected voters, Thomas interrupted a fourth time. Anecdotal evidence isn't the basis for federal intervention, Congresswoman. Perhaps review your constitutional law. The subtle insult hung in the air. Chief Justice Roberts shifted uncomfortably but made no move to intervene. This was unusual. Typically, he would manage the flow of questioning, ensuring all justices had their turn. But Thomas continued unchecked. As Crockett began citing precedent from the 15th Amendment's enforcement clause, Thomas launched his fifth interruption, now clearly testing her legal knowledge. That's a misreading of the historical intent. The framers of that amendment never envisioned the federal micromanagement you're advocating. The pattern was becoming clear to everyone in the chamber. Thomas wasn't just questioning her arguments, he was systematically undermining her credibility, attempting to paint her as legally unprepared and intellectually outmatched. Behind her, NAACP Legal Defense Fund attorneys exchanged worried glances. This case had been years in preparation. If Crockett faltered now, the consequences for voting rights could last generations. For her part, Crockett maintained her composure, though her jaw had visibly tightened. She turned to specific legal tests from prior voting rights cases. In applying the framework established in Arlington Heights and reinforced in... Congresswoman, Thomas interrupted for the sixth time, his voice carrying a note of finality. That framework doesn't apply here. That's not how the Constitution works. The chamber fell completely silent. This last interruption had crossed from legal disagreement into something more personal. A challenge not just to her argument, but to her fundamental understanding of constitutional law. Something shifted in Crockett's demeanor. Those who knew her recognized the look. It was the same expression she had worn in Texas courtrooms when opponents had underestimated her right before she turned the case. Justice Kagan leaned forward slightly. Justice Jackson's eyes narrowed. Even Thomas seemed to sense the shift, adjusting his glasses as Crockett gripped the podium more firmly and looked directly at him. "Mr. Justice," she began, her voice suddenly steel-edged, "I've let you interrupt me 6 times. The 7th will not happen." The gallery held its collective breath. No one spoke to a Supreme Court justice this way, especially not Clarence Thomas. "Mr. Justice Thomas," Crockett continued, her voice now carrying to every corner of the hushed chamber, "before I respond to your constitutional interpretation, let me ensure we're operating from the same factual foundation." She pulled a document from her folder and held it up. "This is your majority opinion in Shelby County v. Holder, where you wrote that country has changed and that the current formula is based on decades-old data and eradicated practices." Thomas nodded slightly, his expression unchanged. "I have here," she continued, placing another document on the podium, "voting data from 173 counties previously covered by pre-clearance. In the decades since your opinion, voter turnout among Black citizens has dropped an average of 31% in these specific jurisdictions." She didn't wait for a response, and here she produced another document. "Are the 240 voting restriction laws passed specifically in these jurisdictions since Shelby County, compared to just 6 such laws in the decade prior?" Whispers rippled through the gallery. Thomas began to speak, but Crockett continued, her rhythm unbroken. "Justice Thomas, you've interrupted me 6 times to question my understanding of the Constitution. But with respect, sir, it seems what you actually question is the evidence." Distinctive. He turned. She turned to a larger chart displayed on a screen behind her. "These aren't statistical manipulations. They're sworn affidavits from 2,461 American citizens who were legally registered but prevented from voting." Thomas shifted in his seat. "Congresswoman, these individual cases don't..." "Your Honor," Crockett cut in, her voice firm but controlled, "I've respected your interruptions. I ask for the same courtesy to complete my argument." The chamber fell dead silent. No one interrupted Supreme Court justices, especially not Clarence Thomas. But instead of anger, Crockett's face showed only resolve. "Justice Thomas, you mentioned the intent of the framers of the 15th Amendment. Let me quote from the congressional record." She didn't reach for notes, but recited from memory. "Senator William Stewart, primary author of the 15th Amendment, stated on the Senate floor on February 6, 1869, The right to vote must be preserved against both present discrimination and future evasions. He specifically noted that without federal enforcement, states would find ingenious means to circumvent the plain meaning of the amendment. A few legal scholars in the gallery looked at each other in surprise. This was deep constitutional history, rarely cited in modern arguments. But perhaps, Crockett continued, you find the Reconstruction Congress too distant from the founding to be authoritative. So let's examine the understanding of the founding generation regarding federal protection of fundamental rights. She pulled out a weathered book. This is James Madison's own annotated copy of the Federalist Papers. In his margin notes for Federalist 51, not published but written in his hand, Madison clarifies that while state sovereignty is essential, it cannot extend to the denial of rights that are inherent to the practice of citizenship in a republic. Thomas's expression flickered for the first time. This was obscure historical evidence few attorneys would have accessed. Justice Thomas, you've built your jurisprudence on originalism and textualism. I'm simply providing the original understanding and textual evidence that the framers, both of the Constitution and the Reconstruction Amendments, understood that federal intervention would sometimes be necessary to protect the fundamental right to vote. She then pivoted, her strategy becoming clear. But let's set aside history and theory. Let's talk about Linda Jackson from LaFleur County, Mississippi. The screen behind her changed to show a 72-year-old black woman. Mrs. Jackson voted in every election for 50 years. After Shelby County, her polling place was closed. The nearest location is now 24 miles away. She doesn't drive. The county eliminated public transportation in 2018. She tried to vote absentee but was rejected for not having the newly required witness signatures. Crockett looked directly at Thomas. Is Mrs. Jackson's constitutional right to vote being honored, Justice Thomas? Is this the changed country you referenced in Shelby County? Before Thomas could respond, the screen changed again. This is Michael Rodriguez, a disabled veteran from Maricopa County, Arizona. He waited 7 hours to vote in the 2022 primary after 70% of polling locations in his predominantly Latino district were eliminated. The evidence kept coming, face after face, story after story, all meticulously documented, all connecting directly to the legal protections eliminated by Thomas's opinion in Shelby County. Justice Kagan leaned forward, clearly engaged. Justice Jackson nodded slightly as Crockett built her case. Even some conservative justices appeared to be listening with new attention. Justice Thomas, Crockett said, her voice now quiet but unwavering, you suggested I review my constitutional law. I have. The question is whether the court will review the consequences of its own decisions. He lifted another document. This is your concurrence in Holder v. Hall, where you wrote that the Voting Rights Act had led to a system of racial spoils. With respect, Justice Thomas, I've shown you the real spoils system, one where American citizens are systematically denied their constitutional right to vote based on where they live, the color of their skin, and their access to resources. Thomas's face had grown increasingly rigid. When he finally spoke, his voice carried an edge rarely heard in the Supreme Court. Congressman Crockett, your emotional appeals and cherry-picked anecdotes don't change the constitutional. Justice Thomas, Crockett interrupted, her seventh line landing like a thunderclap in the chamber. These aren't anecdotes. These are Americans. Americans, your jurisprudence has failed. And with all due respect, sir, when the Constitution begins with we, the people, it meant all people, including those who look like you and me. The chamber froze. No one had ever confronted Thomas so directly about the racial implications of his voting rights decisions. For decades, Thomas had positioned himself against what he called racial essentialism, arguing that race-conscious remedies were unconstitutional. Now Crockett had forced him to confront the racial consequences of his colorblind approach. Using his own words and the documented experiences of black and brown citizens, Thomas stared at her, momentarily silent, something almost unheard of in his recent years on the bench. When he began to speak, his voice had lost its earlier certainty. The court must apply the law as written, not based on desired outcomes. Crockett nodded respectfully. I agree completely, Justice Thomas. That's why I've provided evidence that both the text and original understanding of the 15th Amendment explicitly authorize Congress to enact exactly this type of legislation. erased one final document, and this is your own majority opinion in Northwest Austin Municipal Utility District v. Holder, where you acknowledged, and I quote, "The historic accomplishments of the Voting Rights Act are undeniable." You wrote that before voting to dismantle its key provisions. The screen behind her changed to a simple graph showing the dramatic rise in minority voter participation during the years the Voting Rights Act was fully enforced, and the equally dramatic decline in states previously covered by pre-clearance after the Shelby County decision. The text is clear, the history is clear, the evidence is clear, and the constitutional remedy is clear, Crockett concluded. This court can restore the protections it struck down, or it can continue to allow American citizens to be systematically denied their most fundamental right in a democracy, the right to vote. As she finished, the chamber remained in stunned silence. Thomas sat motionless, his usual judicial confidence visibly shaken. For the first time in his 30-year career, Clarence Thomas had no immediate response. Chief Justice Roberts, perhaps sensing the extraordinary moment, spoke up. "Thank you, Congresswoman Crockett. Does the court have any further questions?" The silence stretched. Finally, Justice Jackson spoke. "I have a question about the enforcement mechanisms in Section 4 of the proposed legislation." Then a questioning continued from other justices. It was clear to everyone in the chamber that something remarkable had happened. Thomas, who had dominated the session with interruptions, sat back in his chair, no longer engaging, reviewing the documents Crockett had presented, his expression unreadable. Crockett had done what many thought impossible. She had rendered Clarence Thomas speechless by confronting him not just with legal arguments, but with the human consequences of his jurisprudence, all while demonstrating a command of constitutional history and originalism that matched his own. As Jasmine Crockett descended the Supreme Court steps an hour later, a crowd had already gathered. News of the extraordinary exchange had somehow leaked from the chamber, and smartphones throughout Washington buzzed with alerts. Court watchers who had witnessed similar arguments for decades called it unprecedented and historic. Within minutes, Crockett TV's Thomas was trending nationwide. Legal commentators who'd been in the gallery rushed to provide analyses, their stunned expressions telling the story even before they spoke. "I've covered the Supreme Court for 27 years, said Nina Totenberg of NPR, speaking rapidly into her microphone on the courthouse steps. "What we just witnessed was unlike anything I've ever seen. Congresswoman Crockett effectively turned Justice Thomas's own judicial philosophy against him, and did it with a command of constitutional history that left the court stunned." Social media exploded with reactions. Progressive legal scholars shared clips from previous oral arguments where Thomas had interrupted female attorneys, juxtaposed with descriptions of today's exchange. The hashtag #TheSeventhLine began trending alongside Crockett Teaches Thomas. Conservative outlets initially tried to frame Crockett's response as disrespectful to the court, but when full transcripts began circulating, showing her meticulous legal reasoning and respectful but firm delivery, their criticism shifted to the substance of her arguments rather than her approach. By evening, both CNN and Fox News had assembled panels of legal experts, their analysis revealing the extraordinary nature of what had transpired. Even conservative commentators acknowledged the moment's significance. "Whatever your position on voting rights," said former Justice Department official John Yoo on Fox News, "we witnessed something remarkable today." Congresswoman Crockett came prepared not just with emotional appeals, but with originalist arguments that spoke directly to Justice Thomas's judicial philosophy. She essentially beat him at his own game. Liberal commentators were more effusive. "This wasn't just a rebuttal," said Harvard law professor Lawrence Tribe on MSNBC. "This was a masterclass in constitutional advocacy." Crockett brought together text, history, precedent, and lived reality in a way rarely seen in Supreme Court arguments. Inside the White House, staffers huddled around screens watching the coverage. Though no official statement was forthcoming, sources reported that the president had called Crockett personally to commend her presentation. Democratic leadership in Congress issued statements praising her brilliant defense of voting rights and courage under pressure. The impact extended far beyond Washington. In law schools across the country, professors scrapped their planned lectures to discuss the implications of the exchange. At Howard University Law School, Thomas's alma mater, students gathered for an impromptu forum on the constitutional arguments presented. Perhaps most significantly, in communities most affected by post-Shelby voting restrictions, people gathered in churches, community centers, and living rooms to watch the coverage. In Selma, Alabama, civil rights veteran Reverend William Barber addressed a hastily assembled crowd. Today, Congresswoman Crockett stood in the highest court in the land and spoke truth not just to power, but to history, he said, his voice rising with emotion. She reminded Justice Thomas and all of us that the Constitution's promises aren't just words on parchment, they're meant to be living realities for every American. For Thomas himself, the aftermath was complex. Court sources reported that he had remained unusually quiet during the justice's private conference following oral arguments. One clerk, speaking anonymously, described him as pensive and less categorical than usual in his initial assessment of the case. Legal observers noted that Thomas had built his career on bold, unapologetic conservative jurisprudence, often writing lonely concurrences or dissents based on originalist interpretations that even his fellow conservatives found extreme. He had rarely shown any public indication that opposing arguments affected his thinking, but Crockett had done something different. She had used Thomas's own judicial methodology, his own words, and his own historical approach to challenge him. She hadn't attacked his integrity or intentions, but had methodically exposed the gap between his constitutional philosophy and the real-world consequences of his decisions. By the following morning, the story had taken another turn. An article in the Washington Post revealed that Crockett's team had spent months preparing specifically for Thomas. They had studied every voting rights opinion he had written, analyzed his questioning patterns in oral arguments, and built a strategy around his tendency to interrupt female advocates. The seventh line response hadn't been an emotional reaction. It had been a calculated move, prepared in anticipation of exactly the kind of condescending interruptions Thomas had become known for. This revelation transformed the narrative from one of spontaneous confrontation to strategic constitutional advocacy. Law professors began discussing the Crockett method of Supreme Court argument. Exhaustive preparation focused on individual justices' vulnerabilities, combined with the courage to respectfully but firmly establish boundaries when necessary. As the week progressed, subtle signals emerged from the court. During arguments in an unrelated case 2 days later, Thomas was noticeably more measured in his questioning, allowing advocates to complete their thoughts before responding. Court watchers wondered, had the exchange with Crockett prompted a moment of judicial reflection? The most significant development came 3 weeks later, when the court requested supplemental briefing on specific questions related to the Voting Rights Protection Act, questions that mirrored issues Crockett had raised in her argument. Legal analysts noted that such requests often indicated the court was seriously engaging with arguments that might shift its approach. For Crockett herself, the aftermath brought both opportunity and challenge. She became an instant progressive icon, with requests for speaking engagements flooding her office. Civil rights organizations called her the new voice of voting rights. Law schools across the country invited her to deliver lectures on constitutional advocacy, yet Crockett maintained a measured public presence, giving just one interview to her hometown paper in Dallas. "This isn't about me or Justice Thomas," she said. "It's about ensuring that every American can exercise their constitutional right to vote without unnecessary barriers. The real victory will come if the court upholds the Voting Rights Protection Act." When asked about her preparation for facing Thomas, she smiled slightly. "I did what any good lawyer does. I studied my audience. Justice Thomas has a brilliant legal mind and a consistent judicial philosophy. I simply engaged with that philosophy on its own terms, while ensuring the human impact of these decisions wasn't lost in legal abstraction." The confrontation's most enduring impact, however, extended far beyond this single case. Throughout the country, a new generation of law students, particularly women and people of color, watched Crockett's methodical dismantling of Thomas's interruptions. With a sense of possibility, applications to law schools saw an uptick, with admissions essays frequently citing the Crockett-Thomas exchange as inspiration. In state legislatures where voting restrictions had been enacted after Shelby County, renewed scrutiny fell on the impact of these laws. Journalists in local markets began investigating the stories of voters in their communities who had been disenfranchised, putting human faces to the statistics Crockett had cited. 6 months later, when the court finally issued its ruling on the Voting Rights Protection Act, legal observers noticed something remarkable. While the decision was complex, with different justices joining different parts of multiple opinions, one passage in particular stood out. In a separate concurrence, Justice Thomas, who had voted with the majority to uphold key provisions of the act, wrote, "While the court must always be guided by constitutional text and original understanding, we cannot be blind to the practical effects of our decisions on the fundamental rights of citizens. Where clear evidence demonstrates that state action has systematically impaired the exercise of constitutionally protected rights, federal remedies may be appropriate." It was a subtle but significant shift in his decades-long jurisprudence on voting rights, a shift that many attributed to that extraordinary moment when Congresswoman Jasmine Crockett refused to accept a seventh interruption, and instead taught Justice Clarence Thomas about the Constitution he had sworn to uphold. The confrontation between Crockett and Thomas had done more than create a viral moment or advance a single case. It had demonstrated the power of principled, prepared advocacy to reshape even the most entrenched judicial thinking, and in doing so it had potentially changed the course of voting rights jurisprudence for generations to come. If you found this analysis of the historic Crockett-Thomas confrontation informative, please hit the like button and subscribe to our channel. We bring you the most important political showdowns and their implications for American democracy. Turn on notifications so you don't miss our upcoming breakdown of how this Supreme Court decision is already affecting voting laws across the country.